So good morning, everybody. I was wondering whether I could say still good morning or good afternoon. We are an hour away from the lunch break, so don't worry. After this wonderful introductory panel, we are now moving to the second panel. My name is Christoph Safferling. I'm the moderator of this second panel, and I'm a professor of criminal law and international law at the university here in Erlangen and Nuremberg. In the first panel, we're given a general overview of this declaration we are discussing in this conference, and we were already introduced into these two terms, peace and justice. Peace and justice. And now this panel is headed by three other terms: justice, prevention, and the end of impunity. We've already seen by one of the questions in the first panel that the relationship, peace and justice, in the declaration is not straightened out. And the relationship between our three terms, justice, prevention, and the end of impunity, is also not strengthened out. What is the linkage between them? Is it peace through justice, peace through law? I think the idea of this chapter here is to look at the relevance of these two terms and the linkage between these two terms from a scholarly and maybe theoretical basis. We won't be focusing that much on case studies. Panel 7 and 8 tomorrow might do that. In this panel, we would look at it from a more theoretical point. And to do this, we have two most distinguished speakers here with us this morning. Unfortunately, I have to say, it's only two, because our friend Chandra Sriram could not come for personal reasons. But never mind, we've got two excellent academics here this morning. The one right next to me, I almost need not introduce because you've already seen her at one place this morning when she opened this conference, because she is, since very recently, the Deputy Director of the International Nuremberg Principles Academy. Viviane Dittrich is specializing in multidisciplinary research and has been educated internationally in France and in England. She holds awards from Sciences Po in Paris and the London School of Economics. And she has also looked into many of these international institutes and tribunals. We are talking about the ICTY, the ICC, and indeed she is also interned, if I'm correctly informed, in the founding office of this academy. So she's well experienced in many fields with insights in the practical field as well. Her PhD topic was present at the completion, creating legacies at the international criminal tribunals. So you would certainly agree with me that she's most fit to discuss these issues with us here on this panel. Suzanna Buckley Cecil is the other member of the panel, and I've known Suzanna for quite some while because of my former university, the University of Marburg. We've met because we called you to be the director of the Center for Conflict Studies at the Philipp University in Marburg. I remember quite well when I met Suzanna for the first time. It was when she wasn't at Marburg. She was still in her previous affiliation in Berlin, I suppose, at the Freie Universität. And we asked her to comment on a research proposal we, i.e. a couple of political scientists, professors and me, drafted to have a very nice TJ project in Uganda. And we discussed that with a handful of colleagues, and we invited Suzanna to come along. And it took about 2 seconds for me to realize that she's really a dangerous woman, because she's extremely sharp and she can sort of point at the crucial issues that have not been sorted out properly. So, Suzanna, I'm happy to be the moderator of your panel now, and you get the revenge you deserve. Now, Suzanna is, as I said, a very renowned expert in transitional justice issues. Just recently, she has been a senior research fellow at the Käthe Hamburg Colleague Center for Global Cooperation Research at the University of Duisburg in Essen, and her research topic was transitional justice as a traveling norm on the influence of local concepts on global ideas. So again, no better person could have been chosen to sit on this panel. So it's on peace and it's on justice. If you look at the declaration, these terms are both defined, and one obviously is very easy to define because it says peace is understood as meaning sustainable peace, full stop. Justice is more complex, and it said justice is understood as meaning accountability and fairness in the protection and vindication of rights and the prevention and redress of wrongs. There we have the word prevention, which is also in the heading of our panel. Enough from my side. Ms. Dittrich will start out with looking at the relationship between peace building and justice. I've asked both of the speakers to contribute 10 to 12 minutes to this topic, and after that we will engage in a conversation together with you. So, Ms. Dittrich.
Well, thank you very much for this very kind introduction. I'm absolutely delighted to be here with you today, and I'm absolutely delighted to be part of this panel discussion, and I think we're very grateful again to the President of the ICC to having sketched many of the very important discussions and dilemmas today, as well as the first panel and the distinguished speakers of the panel, introducing us once again to the 2007 Declaration and the very topical and timely issues that arise and are still ongoing here today. I've been asked here to zoom out slightly to provide a macro perspective on some of these wider concepts that we're debating. Given the progression then of the conference, we will have ample opportunity to dive into much more depth in terms of the empirics, in terms of a number of case studies, particularly in terms of the nexus of peace and justice, with panels in 7 and 8 exclusively dedicated to a number of different case studies that are obviously on all of our minds. So what I'd like to do here today is sketch some of the wider underlying assumptions, some of the wider conceptual debates, and some of the dilemmas in which the fields of transitional justice, both in theory as then in practice, it finds itself. Of course, there's an enormous variability in terms of the practice as we see it taking place in the different case studies across the globe, how the nexus of peace and justice actually have played out. And again, this is for discussion at a later stage. What I'd like to concentrate on here are some of the central themes that have emerged out of the scholarship and out of the more conceptual debates to map the setting and to provide us with some conceptualization right at the early stage. So to begin with, the relationship between peace building and justice is the overarching theme for sketching what is that complex relationship between peace and justice, and ultimately then reflecting back on the 2007 Declaration on the future of peace and justice. So we will take a look at this. You're all very much familiar with the short form of the debate, in that it's been characterized as a peace versus justice debate. I think very much for time being, this very much concentrated and captured the attention of scholars in the field. I think very much there has been a move beyond this, and now there's a much more greater recognition of the richness and the enormous variability and variation between that relationship between peace and justice. So it seems to be, indeed, as was said earlier this morning, that the question is no longer whether to pursue justice, but when, where, and how precisely. And again, this has been answered in very different formats in the respective cases and in the respective settings. In terms of the broader debates, of course, there are a number of conceptual debates and a number of political debates that shape the practice, the politics and the pragmatics of transitional justice in the various local settings. And I think very much there it's important, of course, to recognize the enormous efforts and the consolidation also of the wider international agenda and the efforts of the United Nations in this regard, in terms of the broader peace-building agendas and the various documents that, of course, marcated this procedures and these processes all along, especially the 2004 Secretary General report on the transitional justice and the rule of law in conflict and post-conflict countries. And I think wider questions, of course, emerge about the role of the rule of law, about the importance of the rule of law, and increasingly there are questions debated also at a scholarly level in terms of the rise and decline of the rule of law and sketching these debates more broadly. I think in terms of the debates on the role of peace and the role of what peace actually means, I think opening up some of these wider questions, it seems today that often peace is either defined, if you like, in too vague terms or in too narrow terms for the critics who very much focus on kind of the liberal peace-building aspect of the debate. And obviously being aware of the polysemantic and very complex nature of peace, I'd like to just briefly sketch and dive into some of the conceptualizations and some of the critics in this regard. So initially, the traditional juxtaposition, of course, of war and peace very much shapes any and early discussions of this. And there again, conceptually, there's been a shift from the era of wars to one that is characterized by very complex political emergencies. And of course, there's again a whole host of discussions and distinctions that have been done in that respect. Peace is very much understood as a process, just like justice as well, and their intertwining very much poses many dilemmas and also give room for contestations, which I'll come to in a short while. There's a number of questions regarding this relationship between peace building and justice that have been raised, and I'd just like to sketch a few and give a few here in this prestigious room for us to be thinking about as we proceed with our discussions. How can transitional justice and peace building actually be conceptualized and devised as mutually reinforcing processes, as peace and justice have been described going back to the Secretary General's report? Another question on the mind is how can cause and effect relationships actually be researched in complex environments? And what does that mean in terms of methodological rigor and case study selection and all these other knock-on questions to be addressed? And what is the record, ultimately, of the effects of the legitimacies and of the legacies of post-conflict peace building? And there again, there's obviously ample opportunity and selection of case studies to do this on a case-by-case basis, and a number of factors, a number of debates, a number of controversies have, of course, shaped these in varying degrees. And important as we think about evaluating and renewing our commitment to the fight against impunity is, of course, also the question, how can a principled commitment to justice and a principled commitment in light of the 2007 Declaration, which sees justice very much as an integral and indispensable part of sustainable peace, then be translated into practice, and that the sustainability aspect actually is carried forward and goes on, especially in light of what has been called impunity gap, in the sense that there's vast numbers, of course, of victims, of perpetrators, and compared to the very small number of actual cases and that are tried both at the national and the international level. So again, returning very briefly to the notion of peace itself, and obviously justice is one of the major topics and one of the major concepts here, but briefly on the notion of peace, I think moving beyond the classic understanding of peace, which solely posits peace ex negativo as the cessation of hostilities, or this very much is encompassed already in the 2007 Declaration, that this is a reductionist view and concept of peace, so very much moving beyond that is important. And the sustainability of peace very much needs to be foregrounded. What that means, of course, in practice is a matter that needs to be discussed and needs to be actually assessed very critically. But conceptualizing peace in a binary framework often allows not to sketch the enormous variability that actually exists, and so the dominant conceptualization of peace, and very much undergirded by also liberal normative values and assumptions, have of course received some criticism both in scholarship as well as by practitioners and a number of civil society actors. So I think we need to be cognizant of those debates that have obviously been ongoing. They're not novel, but they have certainly been ongoing. So being very mindful of what it is that can actually be assessed. I think briefly, trying to summarize some of the major critiques of what peacebuilding has entailed, the first critique seems to focus on how peace has been pursued, so very much looking at the sequencing and the timing of peace processes and the particular negotiations that have taken place in that. The second, the maybe more radical critique is that namely of the concept of peace, and if there are alternative conceptions of peace than the liberal peace that seems to be encapsulated and institutionalized, if we like, through the major international institutions that we look at here today. But of course it would take us too far to want to rehash here and reconsider the liberal critique of peace. But I think it is important as we set out to sketch what are the current dilemmas, what are the current status quo of the peace and justice nexus, to bear that in the back of our minds and to be mindful of the often pointed out limitation biases or blind spots, both of the peace building as well as the transitional justice fields. So allow me to briefly sketch a few dilemmas or contestations, or rather openings that have emerged in recent years in terms of points and factors to consider going forward. That peace building as well as transitional justice are not technical endeavors, but very much operate not in an apolitical vacuum, but are very inscribed into ongoing political developments, political institutions and events. So in other words, this idea that clearly there are guidelines and there are assessments or assumptions of principles, values of generality, that no one-size-fits-all approach actually is possible to take, but rather a case-by-case assessment is very much necessary. And being mindful of the politics at various levels, be they international, be it the regional, be it the national, or even the local level, is of course of fundamental importance. The term holistic approach has already been mentioned a number of times, and again there, just sketching what some of the openings and some of the important factors that are to be considered, I think, in any debate going forward is both holistic in the sense of looking at the various sectors, the various arenas of activity involved, so peace, security, justice and development, and we will have more opportunity to look at them and to zoom in more depth going forward. But also in terms of thinking the holistic approach in the form of who are the actors involved. So taking a multi-actor approach, which I think, again, has been very high on the agenda, and there's been a greater sensitization that has occurred in terms of who are the actors and who are to be brought in, both at the peace process stage, as well as then, of course, at the justice stage. And one example that, of course, also the Nuremberg Declaration picks up on is the important role of victims and communities in that respect. And in scholarship, there's been an increasing form also to go to what has been called transitional justice from below, or rethinking transitional justice from the bottom up. Precisely, I think this goes very much in line with what was said in the first panel, the importance also of civil society actors and the broad spectrum of actors that actually exist, of course, on the state level, but bar the state level also. Another aspect that the holistic approach might also be to be considered is that of this idea going beyond legalism, and this has of course been also prominently sketched by a number of scholars, to think about justice mechanisms, judicial and non-judicial form, which may be going beyond the legalistic gravitas, let's say, of a particular approach. So they're suggesting a number of correctives that exist in the scholarship, encouraging a certain legal humility and really thinking again about the broad spectrum of possibilities. Clearly, law's place at the heart of any transition is secure, and an honest appraisal nonetheless of the limitations of this and the corresponding greater willingness to actually countenance the role of other non-legal actors, non-legal forms of knowledge are also very important to play in this regard. So in this respect, participation of a broad spectrum of actors is very much important, also for trust building in the respective local scenarios. And in terms of engagement and this balance between the international and the national, I think very much a shift from merely consulting those affected, but also actively involving in peace processes as well as justice processes becomes very much center stage and an important dimension of any of these procedures. And of course, holistic approach also taking the view beyond a mere legal perspective that political, social, cultural factors are also very much reflected. So this interplay of theory and practice, of law and politics, of politics and pragmatics, very much shapes many of the discussions. And I think there it's critical to recognize that just like the title of this forum's The Fight Against Impunity at a Crossroad, in a way also transitional justice and peace building are at a crossroad. And there are a number of debates to be held, I think, in practitioner circles and policy circles at scholarly levels to really interrogate more precisely what sustainability then of peace ultimately can mean, should mean, and what then the lasting effects, the meanings and the legacies of some of these events, institutions, and ongoing efforts actually can mean. So then, very lastly, this leads to the importance that, bearing in mind Robert Cover's observation that institutions and prescriptions do not exist apart from narratives that locate them in wider meaning and give them meaning. The aspect of meaning is one that cannot be divorced entirely from that. So there, I think there are a number of conversations that are already ongoing, a number of conversations that have yet to be started. So indeed, this is the importance that what meaning people attribute to events, institutions, and processes of both peace building and transitional justice are as important, of course, as the phenomena themselves. And here again, I think there are very interesting debates currently ongoing that we all, I think, pay due attention to and need to systematize in terms of these shifting dynamics, the consolidation yet contestation of norms that is ongoing, and the great ambition and aspirations that we have, and at the same time having this ethos of humility in all of our efforts at the same time. And I look forward to discussing these issues more. Thank you.
The moderator's powers are limited. If she doesn't turn out the mic, I can't speak. Thank you very much, Viviane, for this very interesting presentation of the relationship between these two terms, peace and justice. We've heard that a holistic approach would be appropriate, and we have a multi-level relationship between these two terms. I found it interesting that you always talked about transitional justice. Maybe we can address this later on, what that actually means with regard to peace and justice as being found in the Declaration. Of course, when we look at the Declaration, we see a set of principles in the Declaration, and one principle is the complementarity of peace and justice, and we've heard from Viviane what that entails. And the second principle is ending impunity, and Viviane has also spoken about that, meaning that the controversy between peace and justice, peace versus justice, is actually over, if I understood her correctly, and justice must be done. That is sort of a common sense. The only question is when, where, and how it will be done. When we follow up on these principles, we have principle number 3, a victim-centered approach. That's not our panel, that's the next panel's question. And then the 4th principle is legitimacy. And I think this is where Suzanna can step in, because in her heading of her paper, the term legitimacy is not mentioned, but acceptance. And I think legitimacy and acceptance have a lot in common, but we'll hear more from Suzanna.
Yeah. Well, thank you very much, Christoph, for the challenging introduction earlier, and thanks very much for the Academy to invite me to be on this particular panel and to present work that we have done on the acceptance of international criminal justice, which is called Acceptance because it was a project that was brought to me by the Academy, now 2 to 3 years old, that already had the title Acceptance in the title, or the word acceptance in the title, and we've struggled a lot dealing with this term acceptance. It's been really challenging. This is not the first time that I'm presenting this project, this acceptance project at the Academy. I've presented it at various stages, and we also had panels where people who participated in this project presented their case studies. So to all those people who haven't followed the development of this project in the past, just a few kind of basic ideas what it was about. So the Academy, almost, or even before it was officially launched, felt that there was a necessity to look at how international criminal justice is accepted in situation countries. So the idea was not just to look at legal frameworks, but also to consider the position of people who are actually affected in terms of affected by international criminal justice, in terms of who have to live through the processes in their situation country, who have to deal with the kind of interventions of international criminal justice and the repercussions it has on their country and on the peace and justice they seek to establish after violent conflicts. So what we did was we recruited 2 batches of scholars, we call them fellows, from situation countries. We trained them in very basic social science skills, methodologies. We gave them introductions to international criminal justice ideas. They were all at the level of doctorate or postdoc, and they spent some time here at Nuremberg at the Academy, but then they went back with concrete research questions to research international criminal justice in their country. They did this through a qualitative empirical research. So basically, they conducted interviews with different actors groups in their own country. They wrote that up, and all of this is available on the website of the Academy. Unfortunately, we couldn't kind of throw it on the wall now. But if you go to the website of the Academy under publications, you find a link to the Acceptance Project, and then there is a sublink to the edited volumes, and that consists of individual chapters on the countries, as well as there's a methodology, there's a lessons learned document, there's a state-of-the-art document. So it's kind of a really broad project and output we have, and I very much encourage you to look at this, in particular to read the individual case studies. Like I said, we were struggling with the word acceptance that was given to us because it happens to be in the kind of inception document of the Academy that it wants to look at the acceptance of international criminal justice. And just a minute, I have to put on my glasses. To us, it was we defined it as an agreement either explicitly or by conduct to the principles of international criminal justice in one or more of its forms, legal systems, institutions, processes. So this includes a range of actions from recognizing to giving consent to expressing outright approval. What I would like to do now is to briefly talk you through the findings of these research projects. In total, we looked at, I have to count now, which I won't, I'll just give you the list of countries that we covered: Cambodia, Colombia, Nigeria, Ukraine, Palestine, Uganda, Kenya, Rwanda, Cote d'Ivoire, Lebanon, Kosovo, Bosnia, and Serbia. So we have individual case studies on all of these countries, and then we looked at, what are the cross-cutting themes regarding the acceptance. And what is very important to bear in mind is this is a kind of a micro or meso analysis. We didn't look at the national level. We looked at what individual people our research fellows spoke to, what they felt, or if they felt they accepted international criminal justice. So to talk you through our conclusions or our findings, and some of it is stating the obvious, and some is already been mentioned here. Some aspects might actually also provide some answers on questions that have been raised so far here at the tribunal. So we felt first that, in our research, one current theme was, or one cross-cutting theme was that acceptance of international justice is dynamic and it changes over time. So it's not that something is accepted and then that's it, it changes. Over a period, international courts engage in different activities, such as establishing the court, selecting suspects, holding trials, or delivering verdicts, which may elicit different responses from different groups of society. While some activities, such as the establishment of the court, might be accepted, others might be seen more critical. Acceptance might also change after some temporal distance from the end of the trial. So looking back after a few years, the assessment of the trial might be different than whilst the trial is operating. Second, societies marked by violence, like all societies, are composed of many often highly diverse identity groups, amongst which acceptance of international justice can vary. Political interest groups, victims and their organizations, veterans, faith groups, civil society representatives, and many other different forms offer forms of social belonging and group identity, which may also be defined by their attitude towards the past, in particular if they were directly affected by the violence. There is thus not one society which accepts international criminal justice, but rather many groups with very diverse views regarding acceptance. So here today, often people spoke about the society. There is no such thing as one society. 3, international criminal justice is based on the principle of retributive justice, and in some contexts, alternative forms of providing justice, such as restorative mechanisms, are equally important, so that the acceptance of international criminal justice also depends on the availability and the success of other justice mechanisms. Social and monetary restoration in form of reparations, for instance, are often vital to victims, particularly if they continue to live in precarious economic situations. 4. In contexts where the international justice system was destroyed by violence, where the political climate is so tense that no fair trial are to be expected, or where corruption and nepotism obstructs justice systems, people in situation countries, or certain groups, place very high hopes on international criminal justice. It often seems like the last resort amidst the culture of impunity leading to high levels of acceptance, at least to begin with. At the same time, the intervention of international criminal justice, particularly in form of establishing a court, is often announced as an important contribution to justice and sometimes even as a contribution to reconciliation and sustainable peace. This has been, the topic in the first panels as well. Further, and that's important, raising hopes amongst members of society. Such messages create an overestimation of what a court can achieve and carry the risk of disillusionment and disappointment later on, and thus the withdrawal of the initial acceptance of the institution. 5. In many situation countries, there seems to be an inappropriate communication or a degree of miscommunication between international criminal justice courts and the people, leading to poor understanding. From the perspective of the affected people, in many cases, acceptance is hampered by a lack of knowledge of the workings of a court and the inherent logic of their proceedings. This manifests itself in frustration over lengthy processes, appropriateness of victims, selection of defendants, and prosecution strategies. So what is required is a better knowledge about the court, such as not simply such as attempted by outreach programs, but a better cognitive understanding of the actual working, the procedural workings of the court. 6. For courts, there are limited channels to receive the views of people from situation countries, and in cases where they can be communicated, restrictive structures of courts and rules that leave little flexibility to adjust the feedback of the people affected. This is particularly relevant regarding victims' demands for compensation if there are no provisions within a court to pay reparations. And I think Navi Pillai had the situation with the ICTR where there was an effort to get victims interests in for reparations, but then the structures didn't allow it. 7, acceptance of international criminal justice can be hampered if court activities seem selective, such as only investigating members of one party to the conflict, or by limiting their mandate and operation to particular time spans, geographic areas, or crimes. This can lead to allegations of victor's justice. Selectivity can also have negative repercussions on existing conflict dynamics by worsening the frictions between the party to the conflict. Again, Rwanda might be a good case here. I can stop any time because I can just read the document. 8, that's the benefit of having a numbered list. By definition, international criminal justice takes place in context of violence or post-violence. These contexts are almost always marked by a deeply fractured society, reflecting different parties such as former opponents, new political leaders, and other political interest groups, who all have a stake in the future of their country and who want to assert their role. One way of doing this is by having strong views about the violent past. In the national public discourse, they can demonstrate this by their attitude towards international criminal justice, and thus influence public acceptance or rejection of the process. And the allegations of the ICC, only investigating in Africa is a very good example here. Consequently, international criminal justice often gets between the lines of national politics, particularly if political parties were themselves involved in the conflict. 9, and the last point, the intervention of international criminal justice can have a positive effect on the development of new legal norms in situation countries and the development of the justice sector. Adjusting existing law to international criminal law by amending it, for instance by abolishing the death penalty, or by structural changes such as establishing a special chamber for international crimes in the national court, are significant developments here. If countries want to live up to the standards of complementarity required by the ICC to be able to prosecute international crimes nationally or to have cases referred by courts of third countries, this constitutes a positive form of acceptance. We also call this acceptance. Legal acceptance of international criminal justice norms in form of their domestication into national law is more successful if there are clear incentives for a government to do so. This might include political gains such as the accession to the European Union, and the Western Balkan is here the obvious case, or the referral of suspects for national prosecution from international court or third countries. To briefly conclude, as our research project has shown, assessing the acceptance of international criminal justice in situation countries is essential. And with the growing importance of institutions such as the International Criminal Court, the issue will remain relevant for some time to come. Given that each situation country has particular political and social structures and unique experiences regarding the commitment of international crimes, assessment requires a strong empirical element rather than a search for general insights and normative ideals. To contribute to this richness is what our project has sought to achieve. Thanks.
Thank you very much. Thank you very much indeed, Suzanna, for this information on the very interesting empirical study you undertook. I think we've heard sort of similar things from Viviane on the one hand and Suzanna from the other. One that sort of struck me was that Viviane was talking about narratives that would sort of, frame the context in which any process would take place, peace and justice process would take place. And Suzanne already told us that the social identity and, was relevant also, as I understood it, the narratives of the different societies and whether or not they would relate to what was going on in the peace and justice process. Maybe while you already start to think about your questions that you have for these two speakers, I would maybe like to focus a little bit on the notion of justice. I've already sort of said, commented to Viviane's presentation that I, raised the question, what do you actually understand? You were mainly talking about then transitional justice. What does that actually imply? At the same time, Suzanna has talked about, a retributive approach, a restorative approach of justice, and I was wondering, what the implications of your respective terminology is, and maybe in particular with a view to the topic of our panel, which has this word prevention and the word ending impunity. So does this imply both ending impunity and prevention, or, in other words, is justice more backward-looking, or is it also forward-looking? Viviane, may I ask you to go first?
Thank you very much. I think a very important and critical question. What does justice mean, and what is the implication of a particular notion of justice for then the practical work, but also for meaning-making on a broader scale, if you like. And I think this very much echoes, as Rosemarie Nagy noted, to speak of justice in times of transition actually begs the question of justice for what, justice for whom, and justice to what end, which already sketches the multiplicity of complications that actually enter into the equation when thinking about this notion of justice. I think you've mentioned a number of adjectives that are often used to specify justice, be it international justice, local justice, transitional justice, traditional justice, retributive justice, restorative justice. And I think very much there's a conceptual amalgamation of various concepts of justice, and I think being mindful and being cognizant and very explicit then about what these individual terms actually mean and how they're used, and often, or all too often, they're actually used interchangeably, and that conceptual clarity actually does not take place. So there again, I think the balancing and being mindful of the heterogeneity of all the voices, so that there is no international version or an international meaning attributed to justice, or a national or a local meaning attributed to justice. I think it's precisely in the cacophony of voices, or the cacophony of interpretations, that justice actually takes place, which complicates the picture, and where we see these very much complementary but often at times contradictory trends in terms of assessing the very same event, the very same institution, or the very same process at the same time. And I think having that in mind, this very delicate balance between the international and the local, while at the same time avoiding, of course, the pitfall of romanticization of the local or romanticization of the international, is, of course, a very important one. And I think even the term transitional justice has obviously undergone and comes with an enormous, rich kind of heritage in the sense of scholarship, but also practice and policy making. So it's very, very hard here to, in 2-3 sentences to be able to summarize what the state of the debate there is, and what can be sketched going forward. But I think articulating and rendering cognizant these variations and this importance of interpretation, which comes precisely through, of course, differences in terms of perspectives, multiplicity of actors involved, and also, indeed, shifting of normative discussions, if you like, that are important. And to come to the notion of prevention, which I think is very at the heart of the debate, this has, of course, a longer history in terms of the nexus of justice and prevention, but I think increasingly it's coming to the forefront, also with the International Criminal Court now as a permanent institution, and very much dealing with ongoing conflict. And also a recent initiative I'd just like to highlight of the Human Rights Council in this regard is that currently there is a study that in a way has been requested. The Special Rapporteur on the Promotion of Truth, Justice, Reparation and Guarantees of Non-Occurrence and the Special Advisor of the Secretary General on the Prevention of Genocide were requested by the Human Rights Council in a session in 2016 to prepare a joint study on the contribution of justice to the prevention of gross violations and abuses of human rights and international humanitarian law. So I think we see both at the policy level and the level of practitioners a very in-depth kind of introspection about this relationship, as well as at the more scholarly level where there, of course, the again, conceptual kind of fluidity of the various terms of justice then takes center stage in terms of being able to appropriately assess ways going forward. So I think one last aspect to that is, of course, the focus that generally is on the beginnings of interventions, be they in starting peace processes, in starting justice processes and justice institution, and increasingly, of course, with the completion of the ad hoc tribunals and hybrid courts, there has been an increasing focus on completion, and also in the arena of peacekeeping and peace building, the idea of exit, the idea of completion, the idea of sustainability has taken center stage. So there again, we see a shift in terms of parallel thinking through as new situations arise to already have on the horizon, these temporal horizons are shifting. So what is the more long-term effects? What are the more long-term implications that these have? Thank you.
Suzanna, you want to add on that? The question in particular was, you know, with the terminology you used and the study you did with regard to the notion of justice, is there a preventive effect, or under which circumstances maybe could there be a preventive effect?
Second one is a challenge. I might ignore that part. I think what our research projects in individual countries, but also academic research that goes beyond our project shows is that the pursuit of justice through tribunals is not necessarily fostering peace. It's kind of being a more confrontational kind of structure, having a more confrontational structure within the courtroom, but also within societies, because of educating responsibility, ideally to individuals, but they're often, these individuals are situated in larger identity groups, so they're being, you know, assumed by an identity group saying, well, he fought for us Croats. That has negative repercussions, and I think what one conclusions, or one of my conclusions from the project is, and also on the basis of research I've done before, maybe we should not try to link justice and peace too strongly, and justice and prevention, but like it was also mentioned on the panel before, if courts do justice, that is already a lot, and everything that exceeds that is a nice idea, but if you then look in the empirical cases, often it just doesn't work like this, on the basis of the kind of the whole setup and idea of retributive justice.
So you mean that justice then is an end in itself?
I think I'm saying it should be an end in itself. It should be an end in itself, right? I mean, we're all talking about normative ideas here. We're not talking about evidence-based knowledge, saying that there is a causal relation between justice and peace. This is something that we very much hope that would be the case. But in a sense, I think we also, and this is what we were trying to do with this project, we have to unpack these ideas that underlie conventions, discussions, discourses, and I don't want to say look at the reality of things, but kind of zoom into individual case studies and see how it works. And it doesn't, and again, to come back to one of our findings, if you don't consider a society as one society, but if you look at different actors groups within the society, you might realize that for one actors group, it might actually have some form of, you know, might contribute something to an understanding of peace, however peace is defined, but not for another group, right? And to do it right for everybody is maybe just an impossibility that justice cannot achieve.
I do have two eyes, so with one eye I'm scanning the audience. So raise your hand if you want to jump in and have a pressing question. You're most welcomed and invited. Yes, please. Up in front here.
Thank you. My name is Allison Smith. I work for an NGO called No Peace Without Justice, which tells you where we stand on that question. My question was for Suzanna on the acceptance levels. And all of the points that you mentioned are things that we also find in our work, particularly at the start of, an international justice intervention, let's say, in terms of concerns, in terms of engagement of people in the process. Now, in Sierra Leone, for example, we followed from the very beginning until the very end. Very involved with outreach in Sierra Leone with the Special Court. And we found a link at the end between outreach that was done both by us and by the Special Court with higher positive levels, let's say, of acceptance of the court, of its finding, of its results, and so on. So I was wondering, in your studies, did you find a difference between acceptance levels of situations where there was outreach and situations where there was not outreach? Because I'm always looking to get more information on these. Thank you.
The honest answer is I can't tell, because when you do empirical research, you have to disaggregate a number of different variables, and some of the cases had stronger outreach programs, others didn't. Some were older cases, others were newer cases. So we looked at the first cases, ICTY and ICTR, but also at kind of more recent interventions into Palestine, for instance. So for us it's difficult to trace back what impact the outreach actually had and what kind of societies they reached. And I think that's what's interesting about your work, is that you looked at the same constituency to see whether their attitudes have changed. And that is, we were not in a position to do this, in particular not on the scale. There's interesting work from Fong Pham and others on North Uganda, empirical, quantitative work, where as far as I recall, there's no correlation between outreach and acceptance, but between the development of the peace process and acceptance. So the question, peace or justice, there were, whilst there was outright violence in North Uganda, the idea of a criminal court seemed more interesting than later when they had a peaceful or more peaceful situation as they have now, when this wasn't all that important anymore. So there's so many variables that come together that I find it difficult to disaggregate the impact. But if you only look at the impact like you did in one constituency, then from a methodological perspective, obviously that's an interesting result.
Yes, please.
Nicola Palmer from King's College London. Thank you to the speakers and to the panel. So picking up on Viviane's suggestion of this move towards holistic responses, and Suzanne, what I was reading is your call for more effective communication that goes beyond the current outreach. I wondered if the panelists could comment on a suggestion of facilitating dialogues between international lawyers working inside of international systems and then domestic actors, so both judicial actors who are involved in these processes, but also wider engagement with transitional justice processes, and what you thought the potential was for an exchange of ideas about what these institutions are trying to achieve, but also the possibilities and challenges, so the values that are being ascribed, but also the challenges that are being faced in order to build some of this holistic justice seeking that we've been talking about.
Great, thank you very much for the question. I think you point to a very interesting aspect, which is that of communication, which is that of exchange. And I think being or looking back, taking stock of what has occurred, and with a critical eye, does not in any way seem to or want to dwarf any accomplishments or any achievements, but I think in a way thinking creatively about what could be done in particular settings, what is the most adequate, what is the most relevant manner in which to facilitate these dialogues. And of course, such a dialogue, such exchanges could take various formats, and a number of organizations and a number of actors can very much have this facilitating role or this multiplier role in that regard. So this may be civil society, this may also be international organizations that could take that up. But of course, again, for each context, I think this would have to be done very much cognizant of the idiosyncratic constellations on the ground. I think this dialogue that is mentioned is very important, and there's been an increasing sensitization to this. And I think, again, in terms of the developments of fora that have been created, both officially by the courts or tribunals, as well as other organizations, is a testament that, in a way, this was taken on board and, of course, is part of an ongoing development. I think it's not merely a matter of increasing numbers of dialogue, so a quantitative measure. So the more dialogue there is, the more understanding there will be. Of course, there may be an effect to bringing various actors together that fosters understanding. But again, I think the formats and the timing, so various factors of such exchanges are, of course, invaluable in terms of the conceptualization of that. But of course, completely in agreement with the underlying assumption that bringing actors into dialogue is, of course, a very important step and must accompany in any way to foster understandings, to create meanings, because very much meanings are intersubjective constructions. So in that sense, it's indispensable.
Very briefly, I also think that there should be some engagement, and I think one group that has been quite successful in bringing their voices and ideas in are victim representatives, to the point that in the Rome Statute they now, or the ICC now has a provision for victims, and that is, I think, a major achievement for a social group or representatives of social groups. Victims and victims organizations are not necessarily the same. There are also victims that are not organized, and some organizations don't speak for all victims. But that is, I think, a success story to show how one particular social group managed to get into these processes, get a say, and get eventually some form of justice and some form of reparations. Importantly, though, like I said before, societies are very diverse, and there are other groups that have different views on the justice processes, and the challenge is how to get them involved, because they might not, from their end, they might not be interested in engaging in a form of dialogue. I think that is a challenge. Another challenge would be that we in this room have a lot of very eminent legal scholars who have kind of a strong take a strong stake in their profession and in the area of their professions, but not everybody who works as legal professionals in international tribunals shares that ideal. There is work by Nigel Eldringham, some of you might know, who's done interviews with people at the ICTR just before it closed down, and some of the defenders and others he interviewed, they said, oh well, yeah, I was working in my home country, but then I had this opportunity to come here, so I just seized it. So there might also be a kind of a reluctance on the side of some of the legal experts to actually engage in kind of more with the country they actually are working with, apart from delegations that are being sent to their offices that they, in a sense, have to listen to, like civil society or victims' representatives. So there also, and I guess that's true for everybody here in the room, there has to be a willingness to actually take the country within one works seriously and be prepared to listen, rather than do a good job, and good job is a good job, that's also worth something. Right?
Further questions at that point? It seems to me that we are looking at an indeed very, very complex situation, and it started out so easy with the three terms: justice, prevention, and the end of impunity. And I don't know whether we've actually managed to get some order into these three terms. The end of impunity, I would say, clearly sort of entails a criminal law approach, whereas justice as such doesn't necessarily mean, or it doesn't mean criminal justice exclusively. It has other implications, more restorative implications. And I'm still wondering what we can actually do to make then to then unfold a preventive effect. Can it actually stabilize a society? Can it, as it says in the Declaration, make the recurrence of violent conflict less likely? That's the wording of the Declaration. So what are the connotations? Is it just what turned out in the last question around outreach and dialogue? And if that's not possible, maybe different groups are not willing to speak to each other. I just throw that at you and you comment.
Different groups within the society. Yeah, of course. I mean, they are post-conflict societies. You know, international tribunals are active because there was violence and countries are torn and people have political opinions. That's not surprising. And I think that's just a fait accompli one has to deal with. And again, I mean, as obvious in the case of Kenya or also Côte d'Ivoire, these are moments where then international criminal justice can be used by politicians for their political ends, or like Jelena Supičić wrote with reference to Serbia, international criminal justice can be hijacked by politicians, it can be used to their ends. But again, it's not surprising, but it's a difficult situation, yeah.
To add to that, I think it very much goes again to the heart of the debate in terms of justice and if it's exclusively the focus on criminal justice. Because I think also what emanates and comes out from the 2007 Declaration, I think a greater sensitization in terms of wider discourses on peacebuilding and justice are that addressing the root causes of conflict is of fundamental importance, especially for this preventive dimension of any process in terms of the sustainability and the, in a way, shifting, given that the social fabric in many societies is so fractured, is so fragile, and competing narratives exist not only tomorrow, but also the day after tomorrow and maybe years, decades, or centuries down the line. So I think being cognizant of the complexity of the conflicts, that conflicts obviously have multiple drivers and that some of these justice processes may address a particular aspect or a particular dimension, and even that, in a way, there are, of course, then the bigger questions that are asked, and some criticisms, again, whether real or observed or perceived, only questions of selectivity or bias or marginalization of a particular set of crimes or a particular region or what have you. So I think there again, being mindful of the idiosyncratic circumstances and environments, both legally, politically, and socially, of the respective conflict or post-conflict societies, and then the entire institutional architecture that in a way is part of the transition, is one that will color discussions and debates going forward. So there again, I think a lot is placed on the shoulders. So ever-shifting debates and expectations as they are growing have, of course, complexified this issue. And returning to the title, if I may, of the panel, Ending Impunity is in a way the theological drive, in a way seems to suggest both an endpoint as well as a process to get there. And in the panel one, we already heard that fight against impunity of the international community. Since a number of years, there's been debates and especially by the International Center for Transitional Justice with the symposium that you had a number of years ago, this idea of, is this fight being abandoned? Is this fight being, fought as prominent in the various parts of the world? So there is enormous variability, which I think we have to grapple with and take into account.
Thank you. Then I'd have a question for you to sort of to wrap up what we just heard in this panel. In your view now, she doesn't close her microphone. To summarize in a way, in a question, what we just said. Now the ICC, right, as an institution, it is clearly a criminal court, but it has a victim participation scheme which could produce dialogue, maybe, if I stretch it a little further, and it has a reparation scheme in the trust fund for victims. So is that the ideal institution, or can it be an institution that actually, makes a difference in these contexts, or is it, as what may be alluded before, I think by David Scheffer, saying that it's maybe a little bit over the top, overreaching, and promising something that one institution only cannot achieve?
Shall I start? The ICC is making a difference in terms of ending the culture of impunity by trying individual perpetrators. And I think that is a lot. And kind of, like I stated before, I would not go as far as saying there's a causal link between trying individual perpetrators and achieving justice, prevention, reconciliation in the post-war country.
In terms of the debate and the particular focus of the IC, I think we need to be, again, mindful of the wider dynamics, both in terms of lessons learned by this permanent institutions from all the richness, breadth and depth of experiences that have come before, and at the same time dynamics in a way of reinventing the wheels in some shape or form. So I think there again, while there is to be seen some sort of kind of a progression, if you like, that seemed to be suggested by your question in terms of what has already been learned, what elements have been added to this court in itself, and at the same time, being fair in terms of the criticisms and of course very current debates in terms of crisis mode, perpetual crisis mode. So I think there again, being clear about what is in a way under the control of the International Criminal Court as an institution in terms of its competence and in terms of the ramifications in a way it can take both credit and responsibility for, and what are the wider landscapes in which it enshrines itself. So in other words, what are the wider dynamics that we need to take into consideration to really, adequately reflect, if you like, the complex interplay, again, of law and politics, of theory and practice, and in a way, this vision to promote sustainable peace through justice.
Well, thank you, Viviane, and thank you, Suzanna, very much indeed for this discussion on the very delicate topic of justice, prevention, and the end of impunity. I think we laid the perfect ground for this afternoon's sessions on victim participation, the forgotten voices, and then the final panel of today will be on reconciliation. That was a very interesting discussion. Thank you very much indeed. And now you are free to go to lunch, which is outside the doors. Thank you very much for your attention.